Okay, in my last video we had a little technical malfunction at the end, but I'm going to leave it in there because the editorial quality, the editing is not so great, but I hope the content's enjoyable. Today I want to talk about why my firm and I seek foreclosures instead of money judgments when we handle a collection for a community association client. And there's a few reasons, a couple of which mostly they're related to the unique laws of Florida. So this only applies to Florida. I'm not licensed to practice in other states. This isn't meant to be legal advice, etc. Why do we handle matters the way we handle them? When an association forecloses, well actually when an association sues for delinquent payments, there's a two-count complaint. One is a count for money damages, the other is a count for foreclosure. If the money damages route is taken at the end of the lawsuit, the association receives a money judgment. A certified copy gets recorded in the county in which any property is located, and then the association has to spend time and legal fees and effort trying to find assets of the debtor that can be collected on. In Florida, we have very strong protections for debtors, and that's part of the problem from an association's viewpoint. From a debtor's viewpoint, it's wonderful, but from my client's viewpoint, it's not so good. And the fact of the matter is that there are so many exempt assets from money judgments in Florida, including homestead, that if a delinquent owner actually lives in the property where the association is foreclosing in its homestead, a money judgment can't be used to sell that property. Now, a foreclosure is a different type of a remedy. What we're asking the court for as the remedy for the unpaid assessments is to actually sell the property. And so it doesn't matter whether the property has equity in it or not. What happens is the property is sold eventually. If the bill is not paid, the property is sold on the courthouse steps, and the high bidder usually is the association because these days there's very little equity. What happens in the event of a sale like that? Well, as I've said in numerous other videos that I've posted, the association has title, has the right to possession, may actually obtain possession and displace the former owner or the tenant, as the case may be, and rent the property pending a first mortgage foreclosure. Money judgments are and that is essentially the remedy, and it's a very powerful type of remedy in terms of letting the rest of the community know that there's a moral hazard if you don't pay your assessments. You end up dealing with the consequences of being divested of title. If it's not your homestead, then the association takes title, rents it, and moves on and doesn't pay the mortgage. So for any number of reasons, not the least of which is that money judgments can be discharged in bankruptcy, while the obligation to pay the assessments as secured by the real estate are not discharged by bankruptcy, and that's a very technical area, and we'll leave it at that. My recommendation is that you make sure you have good counsel, that you obtain a cost-effective and aggressive result, and make sure that people in the community understand that if they don't pay, they will be divested of title and maybe possession of their property. And that is really the unique remedy of foreclosure, and there's much less work involved after the foreclosure is obtained. So good luck with that, and we'll see you next time.